Welcome. This is our Afterthoughts segment where we keep our guests around that we had on our television program, and for an extra segment for some extended comments. Today with us we have Anne Marie Storey, attorney with the Redmond Winchell Law Firm. Her concentration of her practice is in labor law. On the segment, we covered a number of new laws that were passed this last session in the Maine legislature, and they've become mostly effective September, right? There was one that we'll talk about, I think, that was effective immediately, was an emergency legislation,
yes.
And there's one that's retroactive, too. So we'll talk about those and make sure that you're clear on that. So we're going to cover the ones we didn't cover on air, but you want to let the viewers know you can see that segment, too, on the website as well. So if you're watching this one on the web, you can also go back and click for that one, too, where we talked about workplace smoking law changes, facilitating lactation in the workplace, breastfeeding changes about breastfeeding in the workplace, and ensuring fair pay law change to the Maine Equal Pay Law. Also, we talked about earlier. So, let's talk about severance pay. Okay. This was an amendment to the current severance pay law, and that's the one that was effective immediately.
This was emergency legislation.
So we may have already violated it several times by now. Okay.
Retroactive back to March 31st.
Oh, okay. I'm not sure how they can do that. But at any rate, severance pay is required for closures and relocations. But this expands it, right, into mass layoffs, is that? And mass layoffs is defined as 100 or more employees?
Yes. It doesn't actually expand the requirement to pay severance when you have a mass layoff. What it does is it requires an employer to notify the Bureau of Labor Standards if there is a mass layoff, meaning 100 or more employees, so that they can then monitor whether that mass layoff becomes what's defined as a relocation or a shutdown, in which case severance pay would be payable.
Okay, so it still is driven by closure or relocation.
Right.
Okay, but a mass layoff may meet that or may lead to that, qualifying for that.
Right. They're going to pay attention to whether or not that becomes one of those other two things.
Got it. Okay, good. And there are some exemptions in there for employers. These are new?
Well, there were quite a few prior exemptions, including if the relocation or termination was necessitated by a physical calamity, if the employee accepts a job at a new location for the same employer, those kinds of things. Right. There is a new exception, and that is if the covered employer has filed for protection under Chapter 11 of the Bankruptcy Code, unless the filing is later converted to a Chapter 7 filing. And I'm not an expert in bankruptcy, so I'm not even going to begin to try and tell you what the difference is between the two. Okay.
And the physical calamity thing, is that new, or is that
no,
definition change?
Physical calamity was previously defined in the Act, but it included an adjudicated bankruptcy, and that part of the definition has now been removed.
Oh.
So physical calamity is now mostly limited to fire, flood, or a natural disaster.
Okay, got it. And also people should pay attention. I think there was a change in what the definition of what a week's pay is.
Yeah, that's actually significant.
A week's pay is a week's pay, right?
Well, no.
All right, tell us what a week's pay is.
Not in my world. A week's pay used to be defined as an amount equal to 1/52nd of the gross pay of the employee.
Yes.
But they've changed that now in case...
They added more weeks to the year?
I hope not. Right. You're now dividing the employee's gross wages by the actual number of weeks they worked, as opposed to 52. So if an employee only works for you for 26 weeks...
that becomes the base.
That becomes their base.
Okay. Well, that makes sense. Employers may not like that, but that seems to make sense on the employee side. Okay. Other things on this one we need to pay attention to?
No, those are the major changes, just to know that it is already in effect.
Okay, good. And this affects most larger employers.
Mostly, yes.
Yeah, so they're going to have probably human resource departments and staff that are watching these kinds of things.
Well, there certainly are a lot of issues that go along with layoffs, reductions in force that are they're already looking into, yes.
Okay, let's go on to the next one. Quickly, tell us about the Act to amend the state statute of limitations under the Maine Human Rights Act.
Yeah, this was changed to make it more in line with the federal law, Title VII, and so it used to be that an employee had 6 months from a discriminatory act to bring a claim at the Maine Human Rights Commission. Okay. They now have 300 days to make that claim, which may not seem like a big deal to a lot of people, but if you're the employer and you have an event happen, the 6 months was, I think, really to make sure that the event didn't become stale, that people don't leave who are important to it without an employer having an opportunity to talk to them and interview them. And so the 300 days could have an impact in that way.
Was there some particular case that was driving this, or was it a Do you know?
I think it was just a regulatory decision, not a specific case.
Okay.
And it also requires the Maine Human Rights Commission to conclude its investigation within 2 years after the date the complaint is filed. So currently there's no specific limitation on the time for them to do that. So that's a change. And then the last change is that the lawsuit, because filing in the Maine Human Rights Commission is not a lawsuit. And a lot of people don't understand that. You still have to go on to file your suit in state or federal court.
Okay.
So an employee now has the longer of either 2 years from the date of the discriminatory act or 90 days after one of several events which occur at the commission, including dismissal of the case, failure to conciliate it if they find in favor of the employee, or issuance of a right to sue letter.
Okay. Okay. That's good to know. Good. The last two have to do with workers' comp issues, which make my hair hurt. And I don't want to spend a lot of time on it. Can you quickly give us the kind of the real thumbnail sketch of what we need to know about those to keep us out of trouble?
Yes. The first one is to clarify apportionment of benefits when there are multiple work injuries. This was a response to a court issued by the Maine Law Court in 2008, a case issued by the Maine Law Court in 2008. And that case had said that if an employee has a prior work-related injury to the same body part, and I'm really paring this down, and then subsequently injures the same body part for another insurance company, it's possible that we could take an offset for what the amount they had received from a prior settlement.
Right.
That's no more.
Okay.
So there's not a lot you need to know about this.
It reverses that. Okay.
The second one is actually, I think, the much more interesting of the two. It also reverses the effects of a Maine Law Court case, and that case had said that...
It was the Grant versus Central Maine Power.
That's right. And an employer and insurance company is bound by the Workers' Compensation Act, of course, in terms of how they terminate benefits. If an employee is receiving benefits under a decree, let's say from a hearing officer, you can't just terminate benefits, even if that person starts another job that pays him or her more than he's currently getting.
Okay.
So there are situations where an employee was collecting double. In other words, we as the insurance company are still paying him because they've got a work-related injury, and then they go out and they get a new job, and that job's paying them too. We have to ask permission, in a sense, to terminate our benefits, and that takes time.
Right.
This amendment now provides a procedure for an insurance company and employer to basically phase out the benefits faster.
Okay, got it. All right, we're going to end it there. There's a lot of good information. Obviously, people are going to need to, there's a lot of stuff here.
Yep.
Go to the website, Department of Labor website. You got to search through it to figure this stuff out, but it's there. Also, you were mentioning the Human Resource Association of Eastern Maine. Tell me about that real quick. And you're going to have a meeting coming up?
We do. We have our first meeting of the season on next Thursday, September 10 at noon at the Muddy Rudder. If people are members, certainly they should come. This is going to be the topic of the talk. If they're not members, they can contact one of the board members, me, if they don't know another one, and get that information to them.
Okay, great. Anne Marie, thanks again.
Thank you.
That didn't hurt. Thanks. Thank you all. That's it.